Now, anticipatory bail. Let's move forward. So, in criminal justice system, what is the purpose of bail? Why do we have bail? What is bail, first of all? See, it is like a temporary respite for a person accused in a crime from detention. There are various kinds of bails. Broadly speaking, you have the regular bail and the anticipatory bail. There are other kinds of bails also, but let's stick to these two kinds. Okay, regular bail is a bail. After the arrest, you will have to take the permission from the court and submit it, and you bring the person out. However, as long as the trial is going on, the person should not breach the set of rules that this bail document has. It's a bail order from the court, and that order is contingent on certain conditions. And the person who is released on that bail should not breach any provision in that order. Only then bail is valid. If he breaches, let's say for example, if the order says you should not leave this city, and if you are leaving that city, you are going to be arrested. That bail stands cancelled. Okay? That is one kind of a bail. Now there is another bail called anticipatory bail. If you think you will be arrested, in such case, the person approaches the court, takes an anticipatory bail. Anticipatory bail, in essence, means you doubt that state is using its power, and you feel that I don't deserve to be treated like that. I don't deserve to be curtailed. My liberty should not be curtailed, and therefore you seek an anticipatory bail. In the previous codes, there are sections which, in the criminal procedure code, there are sections which will talk about this. Like say for example, section 438. The new BNSS 486 section, you don't have to remember the sections. Okay? So those sections will be dealing with the respective provisions. This is the basics of bail. And this is very important in a criminal justice system, because it ensures that even when the person is accused, no person will be treated as guilty until proven. However, there are some cases or some classes of offenses where this principle is inverted. Okay? I will treat you as guilty by default if I am booking you under this case. The burden is on you to prove that you are innocent. What are those kind of cases? Okay. Now, to actually answer that question, let's go to the GS1 society. Anyone with sociology optional also can understand this. In GS1, in Indian society, basic tenets of Indian society, broadly speaking, there are some social evils because of how the society is organized. What is society? It's the way we arrange our society, or the people arrange themselves, organize themselves. There is a certain element of structure, there is an element of hierarchy in that, and there are observable facts in that society. Those facts in the society or in the Indian society are called salient features of Indian society. Casteism, for example, it's a fact. Patriarchy, it's an established fact by sociologists. So, because of centuries together, because of the fact that there is a discrimination of centuries together phenomenon like casteism and patriarchal attitude, they culminate as offenses. Okay? For example, caste slur. You abuse someone based on their caste. You rip them of their dignity because of caste. You rip a woman of her dignity because of her gender. These create social asymmetry. Okay, there is a difference in how you treat one section of the society and the other. This is discrimination, which is a violation of Article 14. And this violation is so grave that it is ingrained in the minds of people. And it is passed on from one generation to another, that it becomes almost instinctive to think like that. And it becomes a generational attitudinal issue. An entire generation will have the same attitude. How do we fix this? And it cannot be fixed just with a law. It has to be fixed. Of course, there should be an intent to fix it through a law, but that alone is not enough. It requires a social change. And these section or this type of laws, where we are trying to use the existing social attitudes, we are acknowledging them within the design of law, and we want law to be designed in such a way that they change the attitude. Okay. With that context, let me explain two cases. One, for example, dowry, and two, the dignity, or I would rather say the insults, that SCs and STs have to face, where they are ripped off their dignity. So there is a act which is famously called the Atrocities Act, and there is Dowry Prevention Act. If you are booked under these sections, the accused is taken as guilty until proven otherwise. This is the background of the entire situation. Now let's come back to the case. What happened here? So there is this case called Kiran versus Rajkumar Jeevaraj Jain. Okay. And it is in this context you need to know. So the person accused, Kiran accused that this person, the other person, has insulted and threatened them with violence, and wanted to book against them a case. So here you have to know about the Atrocities Act, Section 18. In that section, the law says if there is a prima facie evidence, this word is very important. It's a word with a lot of legal weight. Okay, prima facie evidence. You should not give that accused an anticipatory bail. I will explain what this is. The word prima facie literally means on the face of it. Let's say there is something called first information report or FIR. When you go to a police station, especially in cases like this, you go to the police station, you file an FIR. This is the first step. And in the first step, if the accused is blamed by the victim that is indulging in some caste slur, you should by default take it, because the FIR says so. I am booking a case against this person because I got a complaint under that section, and I have proofs that there are some witnesses who said this is actually true. So FIR is the first look, prima facie evidence. Okay. So when you have a prima facie evidence, you cannot, here the court cannot, if let's say for example this person, Rajkumar Jeevaraj Jain, he approached the session court saying that I did not do it. This person is actually from an opposition party, and he's using this legal provision to vilify me. So what did the sessions court say? Okay, as long as the case is under trial, we will give an anticipatory bail. Now High Court also said the same thing. In fact, when the case was taken down, squashed, that person approached the High Court, and in High Court also they said the same thing. Now the case reached the Supreme Court. It is in that context this guidelines came out. Supreme Court said there needs to be procedural integrity. Okay, let's imagine that the person is indeed from an opposition party. Law exists because of extraordinary circumstances. You should check if there is a prima facie evidence. If there are witnesses saying so, how can you ignore even that evidence? There must be some logic to ignoring that evidence. Are you saying that even evidences are planted? It can be possible. But what if it is not the case? What if there is genuinely some problem? You are letting them go now. If the case is false, this person can actually be let go. But what if it is true? You are leaving an innocent person. Sorry, you are doing injustice to an innocent person. Therefore, Supreme Court said that anticipatory bail cannot be granted to this kind of cases, because Section 18 of the Atrocity Act clearly says so. What is the implication of this ruling finally? It gives us the jurisprudence or the logic on how the court thinks. If a law is designed in certain way, there is a very strong reason. Unless that reason is twisted or that reason is changed, you should not change the procedure behind it. What if you are giving anticipatory bail? This person is powerful enough, he can come out, he can manipulate the witnesses, and the entire case goes for a toss. Don't you think it is injustice? And there is a reason why it is not given. So, it is in this type of situations, law should be having that procedural integrity. See, what are the details of the case is not important. Understand how the court is thinking. That logic is what actually helps you in framing answers in the exam. The biggest problem of seniors is that they're focused on this case laws as value addition. But if you ask them to clearly articulate why this is a case, like what is the logic behind it, they cannot articulate the central logic in a shortest possible way. Answer writing is not about this case. It is not about listing the cases. It is about underlying logic that needs to be communicated to the examiner in the shortest possible words. And that logic should be substantiated later by this case laws, which is where most senior aspirants fail to make a difference. Okay? This needs to be fixed. So first focus on the logic, the jurisprudence in any legal issue, especially when Supreme Court guidelines deliver a certain logic. Do not miss them. Okay? Moving on. Otherwise, what is the takeaway from this class? Otherwise, you will end up, just summarizing all these points and you will end up by-hearting them. But when will you learn the argumentation structure? What is the underlying logic? That logic, if not communicated properly, will always confuse you. You will have to rely on memory. Clear? Sorry? Correct. You can conduct a trial. See, okay, that is there. See, bail is a phenomenon that happens pre-trial. Like you mentioned, if the person is really innocent, he will be cleared after the trial. But what if he is not innocent? Even before the trial itself, the case dies. Why do you think this asymmetric power is given to vulnerable sections, whether it is women or SC or ST? These are the historically vulnerable sections where they are very weak in exerting power. However, especially in the case of women, these days we are witnessing a trend of fake dowry cases, fake cases of alimony, especially in urban centers, which opens up a new debate. Should we have a blanket gender biased laws? Dowry cases are not gender neutral. They are in favor of women. If a case is booked, by default, you are saying that the man is accused. You have seen the case recently of a suicide where on Twitter the person expressed his helplessness. That is a grave collapse of governance, I would say. There is definitely injustice. And there was no trial also in that matter. Should that be corrected? Definitely. How? We are yet to figure out. Very unfortunate. But it's for the courts to come up with some framework. And until then, understand this logic.